There we go. Hi guys, it's Christy Cisneros with Finance of America Mortgage, Senior Mortgage Advisor here. And today I am talking with, Attorney Richard W. McGinnis of Law Offices of Richard W. McGinnis. And today I wanted to chat with him and interview him as part of, I really want to share some of his knowledge with all of you. I have worked with him for my own personal estate plan, and I think that trusts are really important for a lot of my clients that own real estate. So I really wanted to bring some awareness to everybody. So, Richard, would you like to introduce yourself?
Certainly, Christy. Thank you. Thank you for having me today.
My pleasure.
My name is Richard McGinnis. I'm an attorney. I've been an attorney since 1983, and my practice is solely involved with estate planning. I have a lot of real estate clients, and I would like to work with Christy. I work with Christy and her family to create their estate plan, and would like to share some information with you today that I think might be helpful for people owning or buying real estate.
Awesome. Thank you so much. One of the I think it's one of the most important things in this process. And I talk to a lot of clients about it. And most of mine, have a trust set up already, and they want to make sure that their home is in the trust. So it's something that I see a lot of, and I really want to bring awareness to. So could you explain to our friends here, what are the primary issues that you discuss with your clients when you're working on creating an estate plan?
That's a good question, Christy, because you want people to really be able to focus on what they can add to this and not the legal issues. That's the attorney's job. So when I speak with people about creating an estate plan, I have three main questions. The first question is, who would manage your financial affairs, pay your bills, handle your real estate or other assets in the event of your incapacity? So we would be talking about a power of attorney for finances there, which would allow somebody to act on your behalf in the event that you became incapacitated. I would then ask about medical decisions. So we would discuss who would be your advocate at the hospital in the event that you were incapacitated. This would be your advanced healthcare directive and HIPAA waivers. And then finally, we would address the issue of what happens to your property at the end of your lifetime. To address those issues, you would use a will and or a trust. There could be other ways to address that, but those would be the most common tools that we would use to address the disposition of assets at death.
Okay. Can you explain the difference between a will and a trust for me?
Certainly. There's three things that can happen. Generally, there's three different plans that people have. The first one is no plan. And when people die with no plan, the state of California makes a will for you, and they determine who your heirs are by degrees of kinship. The court has to determine who's in charge and who the beneficiaries are. This would be a probate proceeding. If you create a will, the will also has to be probated if property is moving through it. Sometimes people create wills and then they have beneficiary designations, or they hold property in joint tenancy with right of survivorship. So the will doesn't necessarily control those assets at their death. But the primary difference between a will and a trust is the administration of the will or the trust when someone dies. Wills have to go to court, and they are probated in the court, and the fees and the costs for the attorney are based upon a percentage of the gross value of the estate. It's tough to determine the average time to do a probate in California right now because courts are so impacted, but we're seeing particularly around here, a year to 2 years before we're able to get even basic probates through the court because of the court's impacted schedule. When people use a trust in place of a will, so if people use a trust as their primary estate planning tool for disposition of assets at the end of their lifetime, we don't typically have to go through the court at all. The person who's named as the successor trustee takes over immediately, and they're able to gather all of the assets together quickly, and then, depending on the terms of the trust, distribute them to the beneficiaries without a court order. This is much quicker, generally very much less cost involved, and allows for people to determine who it is that they want to be in charge of their assets. Trust is very, very important for individuals with young children, because we want to make sure that somebody trustworthy is managing those funds until those children maybe get to be a certain age. And we have provisions allowing for distribution before that age for things like health, education, maintenance, and support. So generally, a trust is going to be much quicker to administer, and allow a lot more input by the person creating the trust about who's actually doing the work and how long things are going to take.
Yeah, no, that was one of the reasons that I did it. It was real estate, and for my kids, I really wanted to make sure that everything was in order if something were to happen to both of us at the same time, and there wasn't anyone there to care for my kids. I didn't want it to all be up in the air, and then we own a home and other things. We started when we were really young, so we didn't have a whole lot, but we've been slowly just making sure that everything is situated, just in case, in the event that something happened. Hopefully that never happens. But what else did I want to ask you? Can any attorney create a trust?
Or anybody who's licensed to practice law in the state of California can technically handle any legal matter. However, usually you don't see a lot of general practitioners nowadays, just because of liability issues and because of the complexity of the legal system.
Right.
So while any attorney could create any legal document, generally my advice would be to work with somebody who focuses on estate planning and does that as a principal part of their business.
And then in the event that something does happen and the people that are assigned in your trust to take care of your assets, you and your office, you would call a meeting, or how does that work? You call a meeting and you work through everything and help them just distribute everything? How does that part work?
Well, if I've created a trust and somebody calls me and says that the people who made the trust are both deceased, or if it's a single person, that person passed away, and they're named as what we would call the successor trustee, then we would discuss with them what are the next steps as far as gathering the assets together, paying the bills and the taxes, doing an accounting for the beneficiaries, and ultimately distributing the assets that are in the trust. So yes, there would be, even though we don't necessarily have to go through the court system, we would want to make sure that we had an orderly progression and that we approach things in a professional manner. There's some things that need to be done at the beginning, getting a tax ID number for the trust and notifying people that need to be addressed before we can take the second step. So proceeding in the right order is very important.
Okay, great. And who would you recommend put an estate plan or trust together? Does it need to be, older people, rich, or what would be your recommendation?
Anybody who's a mortal person can look at this as something that they should consider. So regardless of health, wealth, or anything else, everybody should think about a power of attorney, so that if they're incapacitated, somebody can handle their finances, and an advance directive, so that, again, if they cannot speak for themselves, that somebody who they trust can address medical circumstances. As far as an estate plan, which would include a trust, when people ask me, well, when should we think about a trust as opposed to a simple will? My response question is always, do you own a home? Because if you own real estate in California, a trust can be a tremendous benefit to your family and to the ultimate beneficiaries, because we don't have the waiting periods and we don't have the costs of probate and moving things through a will. So anybody can look at this as something that they should consider. I would say that if you're even thinking about it, you might want to make an inquiry about, is it worth it for me to do it? Are there other approaches that may provide me with similar benefits? And of course, how much do things cost?
In my experience with family that has had real estate that was not in a trust, there were a lot of siblings involved and they were fighting over things, and it ended up costing a lot of money and dragging out. I've always heard that a will can be contested, but a trust cannot. Is that an accurate statement?
No, it's not. A trust can be contested. There's
Okay.
300,000 lawyers in California. And
They'll
they're all
find a
looking
way.
for something to do. All you have to have is money to sue somebody, but you don't necessarily win. That is not really the question. The question is, are you going to prevail? So when we're in court with a probate, there is a ready forum for anybody to come in and create any kind of conflict that they choose to. So the court will address that. That's one of the purposes of the probate. When we don't have a probate, when things move through the trust, it's still possible for people to go to court. However, there has to be a very good reason for them to be there. And in the trust, at least the trust that I create, we do include no contest provisions so that if people actually contest the terms of the trust, they may actually lose any benefit that they would have received, which makes that very unattractive.
Yeah. Okay. And I wanted to also ask you about life insurance. Should life insurance be named in a trust, or sorry, I'm not wording this right.
Well, the issue is, could life insurance be included in a revocable trust? And the answer is yes, it could. Typically, the way that that's addressed is by using beneficiaries. So for married couple, most of the time, their spouse is the primary beneficiary of their life insurance. Right. And then we have the issue of, well, who's the contingent beneficiary or beneficiaries? So that if both spouses are deceased, where does the money go? And so you could also name contingent beneficiaries as individuals, or you could name your trust as the beneficiary. In cases where we have minor children or beneficiaries who maybe don't handle money well, beneficiaries who are on Medi-Cal or other means-tested benefits that they may lose. They may lose their benefits if they receive an outright inheritance. These are people that we really want to make sure that we address the issue of how they're going to get paid and when. And so a lot of times for people with minor children, we will name the trust as the contingent beneficiary because we already have provisions in the trust allowing for a trusted person to manage those funds until those individuals get to be a specific age, for instance, and provide for the opportunity to release funds before that age, again, for typically health, education, maintenance, and support.
Great. Thank you so much. This is such great information. I probably need to make an appointment to come and do some updating to my trust. Now that my kids
you know that since you
bit...
work with me already, you can talk to me anytime. That's something that I offer all of my clients, that they can always call me. They can always email me. I do not charge separately for those. I really want my clients to be in contact with me because, if they need help and they're thinking about it, then they don't have the same peace of mind that they really are looking for when they created it. So I want people to be able to put things away and know that things are going to work, and to know that they can also change their mind at any time. And finally, to know that they have a resource, me, to be able to ask questions if they have any issues later on.
Yeah, I know when I started the process, I thought, I just need to, put my house and, assets in a trust. But then once I sat down with you, there were a lot of other factors to it that I hadn't even thought of. And you brought all that to my attention and explained it all really well to me, which is how I like to do business. Because in buying a home, people don't understand all that goes into it. And so it just reminded me of that. And just sitting down and going through all of it, it was eye-opening for me. So, but yeah, now that my kids are older, I'm thinking, okay, I probably need to give you another call and get
You can
things
talk to me anytime, certainly as
updated.
any
Yeah.
of my clients can.
Yeah.
With respect to people buying homes, particularly married couples, the issue is going to come up right at the beginning about how to take title to the property. And
Yes.
the options would typically be joint tenancy or community property with the right of survivorship. I would, as an attorney, always advise community property with right of survivorship, specifically because at the death of the first spouse, the surviving spouse in a community property relationship gets a new cost basis in the property as of the date of death of the first spouse, which means that all of the appreciation on the taxes on any appreciation of the property up to that point would be completely forgiven.
Oh,
So
that,
for instance, if you and your husband bought a home for $500,000 and then one of you passed away and the property was worth $1 million at that point, and the survivor decided to sell it for the $1 million, they would have no gain at that point because they got a new cost basis equal to the $1 million that the property was worth at the death of the first spouse. Now, again, if it's in trust or we allow your children or other people to inherit it, if the survivor did not sell and then allowed the children or other beneficiaries to inherit at the end of his or her lifetime, there would be another step up in basis at that point. So what we really want to avoid, Christy, is gifting people property because we gift them a low cost basis, which means they have to pay a lot more taxes if they eventually sell. But for married couples, community property is almost always the way to go. But there are circumstances where that might not be the case. So getting legal advice would certainly be useful.
yeah, that's great to know. There's been a lot of tax law changes as well for I end up having to look into them a lot with my clients if they've inherited a property and it's changed a lot and it's not in their benefit anymore like it used to be, at least based on what I've read. So that's really good to know because it's hard. You inherit a property and then now you've inherited this bill basically.
A lot of that has to deal with Proposition 19 and issues related to the reassessment of property upon inheritance if the beneficiaries aren't going to use it as their principal residence.
Right.
So used to be we were able to get a parent-child exclusion on any type of reassessment issue if parents died and left a home, for instance, to all or some of their children.
Right.
As long as they held it that way, there's no reassessment for county property taxes. Proposition 19 changed that, and so we're looking at a lot of other issues here. But generally speaking, if the beneficiaries are not going to live in the home, there's the possibility that the county will reassess that property as if it were a new owner.
Right. Well, and just the difference in the what you mentioned previously, the from transferring from one spouse to the other in the event that one spouse passes, that gain there, it seems like that would be very helpful to people when they've lost a spouse.
Christy, when people lose a spouse, or even when they're deciding to create their own plan, I get a lot of calls, and I actually see in my practice way too many deeds that people have created themselves. And I'm not sure why that people do this.
Yeah.
They get a form and then they fill it out and then they go record it and it gets recorded and they think, well, that's fine because the county recorder recorded it.
Right.
But I can tell you that's one of the biggest problems that I see is, and I don't know why, I do know why, it's a cost issue, but I see a lot of people who have property worth hundreds of thousands or millions of dollars, and they then write their own deed. And I don't know why you would do that given the risks that are involved. And so one thing I'd like to talk to people about is how does this stuff actually work? Because there are a lot of different choices that you have here. You can create a will, you can create a trust, you can be joint tenants, you can be community property. And there's actually quite a number of other ways that you can address any kind of plan, including creating corporations and limited liability companies. But for me, what my focus is to listen to what people want to do, look at the assets that they have, and then offer options as far as choices. And there always are choices, and each choice has benefits and detriments. And so what we really want to look at is what makes sense for the individual and not having a one size fits all type of a plan.
Absolutely. Yeah, it's so important. It's just like buying a house and financing it, what program works, what's going to work best for that client. What do they, I have a lot of people that think, oh, I want to do this program. And it's like, well, you would be better suited for this. It's really important. So I love that. Thank you so much for that. And thank you for allowing me to interview you today. I appreciate all of your insight. And I know that it will help a lot of people. So thank you. Do you have anything else that you would like to share with us?
It's my great pleasure to meet with you today, Christine. It was my pleasure to work with you and your family on your estate plan. I look forward to talking with you soon about things that you would like to address.
Yes.
And
you.
last thing I would say is, estate planning and choosing someone to assist with an estate plan is a very personal matter. If you really should be comfortable with the person that you're dealing with, because this is a peace of mind document that once you put it away, you want to not think about it anymore and know that you did the right thing.
Yeah.
You can always change your mind about most of these types of plans, but getting started is sometimes the hardest part. So this is not, talking about death and dying is not something that people just gravitate toward. But I find that once people address it and we put something together, that a weight is lifted off their shoulders and they really feel a lot better having made the plan. So I do offer consultations. I'm in Roseville. I'm happy to talk to anyone on the phone. I do meet with people in my office. And I appreciate meeting with you this morning here and getting some information out to your people so that they make better decisions.
Yes. Thank you so much. I so appreciate it. I learned a lot, and I will definitely take this information and talking with my clients and refer them to this video for more. So thank you again. I appreciate it. Have a great day.
Thank you very much, Christy. I appreciate talking with you this morning.
You bet. I will talk to you soon.
Okay.
Bye-bye.
Bye-bye.